respects to their elders past, present and emerging. As an organisation, Piddington operates within the legal and the justice systems, and I acknowledge that these and other Western systems of government have been and continue to be complex and often traumatic places for Indigenous people. Well, what a day to be talking about the voice to Parliament and the upcoming referendum. It's maybe even like we planned that. The Prime Minister, surrounded by First Nations people and other experts advising on the referendum, announced this morning that the proposed question has been updated and will be, subject to Parliament's approval, a proposed law to alter the Constitution to recognise the First Peoples of Australia by establishing an Aboriginal and Torres Strait Islander voice. Do you approve this proposed alteration? Further details released today include that the voice may make representations both to Parliament and to the Executive. In other words, it may make representations to the ministers in Parliament who make the laws, the Prime Minister and the Cabinet Ministers who carry out the day-to-day government of the country, and to the people in public service who advise the government of the day and implement government and parliamentary decisions. The referendum will also, it's also been announced that the referendum will be held on a Saturday after the end of September to avoid double booking with any important Australian religious holidays. Grand final day. While we will likely touch on the updates today, we want to focus this session closer to understanding the facts and the issues of the voice, such as its place in the legal system, constitution, and how it may operate. For those of you who aren't aware, the Piddington Society is a not-for-profit organisation of lawyers based in Western Australia, and we're guided by our objects to support junior lawyers in the profession, support access to justice, and high-quality professional development. Proceeds from our activities, including events like today, go towards our Access to Justice projects, including the Piddington Practical Legal Training program, which pairs new graduates with community legal centres and pro bono work, as well as the Piddington Justice Fund for community legal centres to cover costs they would otherwise not meet, and Cutagen, our First Nations Legal Education Fund. In April, we will be making announcements about recent grants that funds have made. As I mentioned before, improving access to justice is one of Piddington's main objectives, and one way we try to do this is by identifying complex legal issues and asking people with experience in that space to explain those matters, and if possible, simplify them. We hope that you will leave today's session with a better understanding of the proposed Aboriginal and Torres Strait Islander voice to Parliament and the upcoming referendum, and we're delighted to be joined today by an esteemed panel of speakers to demystify and decomplicate the facts about and the issues which have been raised in relation to the voice to Parliament. We'll begin the session with some remarks by our speakers on these facts and issues, followed by a Q&A session. So without further ado, I will briefly introduce our speakers in the order that they will speak. First up, we have Sophie Coffin, one of two Uluru Statement Youth Representatives for Western Australia. An admitted lawyer, Sophie is a Ngangumarta, Yindjibarndi and Palyku woman. Next, we will hear from the Honourable Robert French, who was the 12th Chief Justice of Australia, serving from 2008 until 2017. And prior to his appointment as the Chief Justice, Mr. French was a judge of the Federal Court of Australia for over 20 years and the inaugural president of the National Native Title Tribunal. The Honourable Ben Wyatt will close out the first part of our session. Mr. Wyatt is a former Minister for Aboriginal Affairs in Western Australia and was a member of the WA Parliament for 15 years until 2021. Before this, he worked as a lawyer, and through his father, Mr. Wyatt has Yamatji heritage. I'll now pass over to Ms. Coffin, who will provide background on the voice and why we're heading to a referendum. Thanks, Sophie.
Thanks, Bryony. Hi, everyone. I'm Sophie. As mentioned, I'm a proud Ngangumarta, Yindjibarndi and Palyku woman from the Pilbara. I'm currently working as an associate to the Chief Justice at the Supreme Court, and I'm feeling really lucky to be here today with our other esteemed guests, the Honourable Ben Wyatt and former Chief Justice Robert French. Before I begin, I want to acknowledge the Whadjuk people of the Noongar Nation whose land we're on today and pay my respects to elders past, present and emerging, as well as my own elders, and also acknowledge Conrad in this room and Bryony, who have helped put this together, and my mum Julie, who's here supporting, so welcome. So today I want to talk a bit about the background to the voice, the lead up to getting to where we are today, and not only the how, but also the why. So before I get into that, I want to talk about why there's a need for change. So currently there is insecurity of Indigenous people's status in the machinery of government when it comes to laws and policies and institutions. First Nations Matters is an area of public policy that's continually interrupted, disrupted with each change from one political party to the next. And from one 3-year term to the next, it's constantly the subject of experimentation by bureaucracies and governments. The state of disruption means that people and communities on the ground have little say in the longevity of programs and policies that affect them. The Voice to Parliament reform is intended to bring security and certainty to people's lives that will manifest in better outcomes for communities. Being constitutionally enshrined, the voice will be sustainable and durable well beyond political timetables. It means that Indigenous empowerment and active participation in the democratic life of our nation is not dependent on which political party is in power at any given time. It isn't good enough that right now we're overrepresented in the criminal justice system, our youth in the criminal justice system. We have the highest rates of youth suicide in the entire world. We have a far lower life expectancy. There's prevalence of death in custody. We have prevalence of disease and infection in our communities and in terms of health outcomes. And it's been proven across academia, across the world and across disciplines from health to law to environmental, that issues that affect communities have the best outcomes when people from those communities create the programs and solutions to target those issues. And so the voice will work towards that on a greater scale. In short, the voice will be a permanent body to make representations to the Australian Parliament and the executive government on legislation and policy of significance to Aboriginal and Torres Strait Islander people. It will further the self-determination of Aboriginal and Torres Strait Islander peoples by giving us a greater say on matters that affect us. So throughout our shared history, there have been consistent calls for constitutional recognition for First Nations people and a representative voice in decision-making, as well as the right to self-determination treaty and truth to be told about our nation and our shared history. The work on recognition of First Nations people in the Australian Constitution has been happening for decades, and today especially is the culmination of decades of hard work in this space. Since 2010, we've had no fewer than 7 mechanisms and 10 reports attempting to deal with recognition in the Australian Constitution. Notably in 2015, after a number of processes, reports and committees, the Kirribilli Statement was issued by the former Prime Minister, along with 40 Indigenous leaders who met with the Prime Minister and Opposition Leader to ask for a new process of consultation. The statement stated that that any reform had to involve substantive changes and that anything symbolic like a preamble was unacceptable and would not actually create substantial change. It doesn't go far enough. The then Prime Minister Malcolm Turnbull and Opposition Leader Bill Shorten established the Referendum Council, and this council is really important for the next phase. The council was made up of 16 Indigenous and non-Indigenous leaders and members, including Auntie Pat Anderson AO, Professor Megan Davies and Murray Gleeson AC and Noel Pearson, among others. It was the First Nations members of that council who designed the regional dialogue model, and that process was carefully deliberated, designed and tested out over 2 years before being rolled out in communities in 2016. That took place from 2016 to 2017, and it basically involved those members going out to communities and speaking with communities and representatives about civic and legal education first, and then what options there were for structural reform. Those in attendance were deliberately made up of 60% First Nations and traditional owner groups, 20% Aboriginal and Torres Strait Islander community-controlled organisation representatives, and then 20% key individuals. Youth participation and gender balance were also important considerations. And as mentioned, the delegates were asked what meaningful constitutional reform meant to them. In the discussions, the 6 principal reform options were offered to participants, and I want to read these out so that you can see everything that they considered and that why this was the final choice as a result of that. So firstly, there was a statement of acknowledgement within or outside of the Constitution. Secondly, an amendment or replacement of the race power. Third, repealing Section 25. Fourth, constitutional prohibition on racial discrimination. Fifth, agreement making. And sixth, an Indigenous voice to Parliament with a base in the Constitution. In working groups, the delegates examined and reported back on the reform options, including possible benefits, concerns, and what their preference would be going forward. Symbolism was immediately struck out because, as mentioned, it didn't go far enough and people wanted a say over issues that affect their lives. And the reform has to be substantive and structural to give power to that. It had to give us a platform and give our people political power to actually engage in the democratic system that has silenced us and shut out Indigenous people, which enabled policies and decisions to continually be made about us, keeping the status quo going forward. So we want to address and change that. The dialogues were comprised of over 1,200 First Nations people from all different language groups. And at the end of the few days that they met with the referendum council members, certain delegates were chosen and put forward to then meet in Uluru at the Uluru Convention in 2017. And that's where the Uluru Statement from the Heart comes from. All of the members who went to Uluru, they all read out the minutes from each of the regional dialogues. They then signed off on the minutes to ensure that that was a true reflection of what was discussed. And then they came together to again discuss what everyone wanted. The outcome of those dialogues was the call for constitutional reform in the form of a First Nations voice to Parliament to advise Parliament, followed by treaty and truth-telling processes. It's really important to understand that process that got to this point. It was unprecedented, and that level of consultation is also unprecedented. It was grounded in self-determination. It was created by First Nations people, for First Nations people, run by First Nations people, and delivered by First Nations people. So now I want to talk about why voice, treaty, truth in that order, and particularly why the voice has to come first. So that is deliberate and was carefully considered by the delegates at Uluru, as well as in the regional dialogues. The voice has to come first, not because it's necessarily more important, but because it is the substantial and structural change that allows First Nations people to have self-determination and political power to then engage on Makarrata, and that means coming together after a struggle. So the second phase of the statement is treaty and truth, and that comes under Makarrata. So it's important to have the first step to give us the power and a seat at the table for those processes that will follow in treaty making and a truth-telling commission, rather than treaty and truth becoming ticking a box exercise. The voice is the next pragmatic step towards achieving self-determination and having the right people at the table. The voice that the delegates to the regional dialogues envisioned, and which the constitutional amendment must achieve, is that it must establish the First Nations voice as an enduring form of recognition for Aboriginal and Torres Strait Islander people. It must describe and protect the voice's primary or core function of conveying the views of First Nations people to Parliament and government in the development of policies and laws that affect First Nations people, and the ability to compel the Parliament and the government to listen. It must empower the Parliament to legislate the detailed design of the voice and make necessary amendments over time to adapt to changing circumstances, as well as the flexibility to allow the voice to talk to the states and territories. And so from here, what does the next step look like? There are advisory groups that are advising the government, and you will have seen today when the Prime Minister made an announcement, members of those groups that have been in consultation and negotiation with the government were standing there beside him. There is the referendum engagement group, and that's made up of Aboriginal and Torres Strait Islander representatives from across the nation, land councils, local governments, community controlled organisations, and their role is to provide advice in building community understanding, awareness and support for the referendum. And then we have the referendum working group, which provide advice to successfully implementing the referendum so that it goes through, including timing the question which we saw today and the proposed amendment, which will be finalised next Thursday. and that is comprised of a broad section of representatives from First Nations people across the country. And that is mostly what I wanted to cover off on. So I'll now turn to Chief Justice French to continue. Thank you.
Thanks very much, Sophie, and thank you for laying out the history so clearly so that people know where we are. I just want to step back for a very quick moment to the beginning of the Constitution to just make reference to a couple of key provisions and amendments that have preceded this. When the Constitution was enacted as a part of an imperial statute in 1901, it referred to Aboriginal and Torres Strait Islander people only by exclusion. So we had section 51(26), which gave the Commonwealth Parliament the power to make laws with respect to the people of any race other than the Aboriginal race in any state for whom it is deemed necessary to make special laws. And there was also section 127, which said, in reckoning the numbers of the people of the Commonwealth or of a state or other part of the Commonwealth, Aboriginal natives shall not be counted. Now, those two exclusionary provisions, the race power, section 51(26), which had left the lawmaking power with respect to Aboriginal and Torres Strait Islander people to the states, and section 127, the no count provision, were the subject of the successful constitutional alteration Aboriginal 1967, a referendum. Section 127 was repealed. Section 51(26) was amended to extend the race power by taking out the exclusion of the people of the Aboriginal race in any state. So now it reads simply that the Commonwealth can make laws for the people of any race for whom it is deemed necessary to make special laws. Now that significant change, significant as it was, did not involve any express recognition. In fact, in many ways, it's quite unsatisfactory because it put Aboriginal and Torres Strait Islander peoples into the bucket of races about any of whom the Commonwealth could make special laws. As Noel Pearson observed after the 1967 referendum, he said it reversed exclusion, but it left us with a constitution that now makes no mention at all of this nation's Indigenous history and heritage, and still contains racially discriminatory provisions. Now, as Sophie, I think, indicated, there's been a long history of public advocacy for recognition of the special place of Aboriginal and Torres Strait Islander peoples in Australia. And the role of prime ministers who've been involved in the movement one way or another is extraordinary. Gough Whitlam, Malcolm Fraser, who established the Senate inquiry into Ngangumarta, Bob Hawke, who committed to a treaty or compact, Paul Keating in his Redfern speech, John Howard on the eve of losing the 2007 election, and Prime Minister Gillard, who established the expert panel on recognition of Aboriginal and Torres Strait Islander peoples in 2010. And then you had Tony Abbott, who established a Joint Select Committee on Constitutional Recognition, co-chaired by Ken Wyatt and Nova Peris, which reported in June 2015. Then Prime Minister Turnbull and Opposition Leader Shorten were established the Referendum Council in December 2015, and Sophie's referred to the famous Turrbally meeting. And then we had the expert panel, which recommended the insertion of 3 new provisions in the Constitution, providing for recognition, the prohibition of racial discrimination, and the recognition of languages. But that was too contentious to succeed, so an alternative approach was needed, and it was in that context that the idea of an Indigenous advisory body was formed. And so that led us to the point that Sophie took us to, the Uluru Statement from the Heart, which in the last sentence stated, we call for the establishment of a First Nations voice enshrined in the Constitution. Now, one immediate point I want to make about the voice before I go to the text of the proposed amendment is that the proposal does not rest upon the status of Australia's First Peoples as a race. It rests upon their historical status as Australia's First Peoples. And this accords with the United Nations Declaration on the Rights of Indigenous Peoples, for which Australia voted in 2009. And in Articles 18 and 19 of that, you'll see reference to recognition and self-determination and taking into account their views. It is entirely consistent with the International Convention on the Elimination of All Forms of Racial Discrimination, and the contentions to the contrary, which have appeared in some of our national media, that this somehow is in breach of the international conventions. That's absolute nonsense. It is in fact giving effect to our obligations under the Declaration on the Rights of Indigenous Peoples. Now, let me take us to the text briefly, it begins with the introduction of the new Chapter 9, as announced today, headed Recognition of Aboriginal and Torres Strait Islander Peoples. And it's then entitled Aboriginal and Torres Strait Islander Voice. And so we have the preambular statement in recognition of Aboriginal and Torres Strait Islander peoples as the first peoples of Australia. So that's the recognition bit. 1, there shall be a body to be called the Aboriginal and Torres Strait Islander Voice. That's the first thing. 2, what are its functions? The Aboriginal and Torres Strait Islander Voice may make representations to the Parliament and the executive government of the Commonwealth on matters relating to Aboriginal and Torres Strait Islander peoples. And the words of the Commonwealth have been inserted, and that represents a change from what was announced at the Gama Festival by Prime Minister Albanese. And thirdly, the Parliament shall, subject to this Constitution, have power to make laws with respect to matters relating to the Aboriginal and Torres Strait Islander Voice, including, you know, that word including, the lawyers will immediately prick their ears. I say including means not limited to, including its composition, functions, powers, and procedures. And that insertion of the word including is an important change from what was announced at Gama. So what can we say about these provisions? And I'm sorry to focus in on the, if you like, the textual legal things, but I think that's perhaps what people are most interested in hearing about from me. The first constitutional element of the voice is that it will be a body. There will be a body, etc. And the relevant ordinary meaning of that word is a group of people who work or act together. And the only constitutional requirement in relation to the body under the first paragraph is that it be called the Aboriginal and Torres Strait Islander Voice. Now, of course, there's been much stated in the press about and in public discourse about the need for detail about the body. Whatever detail is given about the body to be called the voice, it is not part of the constitutional change. It cannot be guaranteed that the Parliament will legislate to make the body or create a body in accordance with what is said prior to the referendum, although there may be political pressure to do so. What we know is being outlined in the statement made by the Prime Minister today. He said, he referred to what he called important principles that will underpin the shape and function of the voice. Those principles have been developed by the referendum working group, and this morning they were adopted by my cabinet. Firstly, the voice will give independent advice to the Parliament and the government. It will be able to make proactive representations as well as respond to requests. And the Parliament and executive government should seek written advice from the voice early in the development of proposed laws and policies. So there's a two-way exercise. The voice will be chosen by Aboriginal and Torres Strait Islander people based on the wishes of local communities, not appointed by the government. Members will serve for a fixed period of time to ensure accountability. It will be representative of Aboriginal and Torres Strait Islander communities with a gender balance and include youth. Members will come from every state and territory, the Torres Strait Islanders and specific remote representatives. It will be accountable and it will be transparent, subject to the standard governance and reporting requirements. The voice will work along existing organisations and traditional structures, respecting their work, and as has been made very clear very many times, the voice will not have a veto power and it will not deliver programs or manage funding. Now, a detailed model that embodies a number of those principles is the co-design model prepared by Marcia Langton and Tom Karma, following a very extensive report, and that is not necessarily in detail the model that will be adopted. It will depend on the Parliament, on the assumption, of course, that we get the referendum through. So the function of the voice is set out in paragraph 2 to make representations. And again, the ordinary meaning is official statements to the Parliament and the Executive. They would cover submissions of advice about existing or proposed laws and administrative policies and practices. And so often in the area of policy and practice, the soft law that you'll find in departmental manuals or guidelines, that is the law for many people at the front counter or in the trenches, whichever metaphor you like to apply. There is no constitutional legal obligation, in the words of the amendment, for the Parliament or the Executive to accept or be bound by such submissions or advice. There would, however, be what I've called a high democratic obligation to respect them and take them into account. That doesn't necessarily translate into a legal obligation. Now, the voice may make representation about, quote, matters relating to Aboriginal and Torres Strait Islander peoples. Now, that term, as many lawyers will know, relating to, appears in lots and lots of statutes and has an elastic application depending upon the context and purpose of the provision in which it appears. So what can we infer about it at this point? We could say that laws, policies and practices relating to Aboriginal and Torres Strait Islander education, training, family, social welfare, health, remote community services, community policing, Aboriginal art, cultural and heritage protection, traditional ownership of land and waters are well within that range. But beyond that, there'll be representations perhaps concerning laws or policies of general application which have a particular effect on Aboriginal and Torres Strait Islander people, what we might call operational discrimination, with which many of us might be familiar. The third paragraph of the amendment confers power on the Parliament to make laws to give effect to the voice. Now, this voice doesn't exist until the Parliament makes a law establishing it. It doesn't exist by virtue of the Constitution any more than the High Court existed by virtue of the Constitution back in 1901. In fact, there was a strong movement from some state governments at the time not to have a High Court trial because it's going to be too expensive, even though the Constitution said there shall be a High Court of Judicature. They said, oh, we can do this with a bunch of state chief justices. And Alfred Deakin made a huge, long, impassioned speech where he called the High Court, I think, the arch, the keystone of the Federal Arch. But they needed legislation to put it in place. And analogously, legislation has to put in place the voice. And the Constitution doesn't tell us precisely what its composition will be beyond the very broad parameters that are already mentioned, what its functions will be. The third paragraph so confers power to make laws to give effect to the voice. It includes, and as I said before, this is a new word. It includes. It was previously just going to make a power for the Parliament to make laws with respect to the composition, functions, powers and procedures of the voice. Now it is proposed that it makes laws, that it can make laws with respect to matters relating to the Aboriginal and Torres Strait Islander voice, including its composition, functions, powers and procedures. Now, composition, functions, powers and procedures is easy in a sense. Such laws will be necessary to establish the voice and to create the mechanisms and clothe it with the powers necessary to carry out its function. The Constitution doesn't mandate a particular model, and the Parliament can change the laws from time to time in the light of experience. The scope of the power is wide because it is not limited to composition, functions, powers and procedures. It might extend to a range of things, including the duties, if any, of the executive in relation to any representation and the legal effect of such a representation. Now, you might have heard that there was talk about the Attorney General Dreyfus wanting to insert the words "and the legal effect of any representations" in paragraph 3. Well, that's not there. Instead, you have this broader power which could accommodate a power to determine the legal effect of representations, but a lot more besides. And it may well be, for example, that from the perspective of First Nations people, they want to see that power so that Parliament might be persuaded, for example, to enable the voice to lobby and have things to say about cooperative federalism and the relationships with the states and territories, which ultimately I think is going to be fundamental to the proper working of this thing, because there are so many programs where you have state and territories involved where the rubber really hits the road in terms of Indigenous disadvantage. Parliament can't make a law which can confer on the voice a legal right to veto a proposed law. Parliament can't make a law limiting its own law-making powers by legally requiring prior consultation of the voice. The voice is not a third chamber, despite the legal opinion of the former Prime Minister. The constitutional amendment would, however, support the adoption by Parliament of internal procedures to provide for the voice to be heard. Maybe the setting up of a standing committee, a standing joint committee of some kind, which would be an important point of contact. It could also make a law defining the means by which Parliament would make its representations. And let's look at this troubled area of the executive. It could, for example, determine that representation for the executive government must be made to the relevant minister rather than directly to public officials. Because every minister is responsible for most public officials. And you do have some independent statutory authority, but even they have ministers who are ultimately responsible for them. It might provide for the establishment of protocols between the Parliament, the executive government and the voice, which set out classes of case in which the voice is to be notified of proposals, be they laws, policies or practices. What about the courts? What role do they have to play? I won't go on a bit because there might be some Q&A here, but I think there's little or no scope for constitutional litigation arising from the words of the proposed amendment. It is facilitated and it's empowering. Parliament can't legally be compelled to make laws for the voice. It can't be compelled to make a particular kind of law, and it can't be prevented from repealing or amending the laws it makes. Now, I've set out on previous occasions some arguments about whether there's some constitutional implication that the executive would be bound in the exercise of executive power to have regard to a representation relevant to the exercise of that power as a mandatory relevant consideration, which then becomes a condition of the valid exercise of the power, which if you don't address it is what's called jurisdictional error. And I think that that is highly improbable, and the improbability, I think, is enhanced by the scope of the power of the Parliament itself under the including bit in paragraph 3 to address the proper relations. When you think about it, the huge range of things upon which the voice might want to make representations to the executive, which are plainly non-justiciable, high-level policy practices, the sorts of things which are outside specific statutory exercises of executive power or even non-statutory executive power, it rather militates against the proposition that you could carve out of that range of representations relating to particular exercises of executive power and say there's a constitutional implication attaching only to that bit. That's what strikes me as somewhat improbable. Now, of course, one should never say never in the law. And anybody who has a lawyer who says you're going to win should change their lawyer. So that's all I have to say about that at that stage. So in conclusion, I think that the voice proposal is a once-in-a-lifetime opportunity for us to fill what I call a moral and historic shortcoming in our constitution, the recognition of our first history, and the creation of a practical opportunity for First Peoples to give informed, coherent and reliable advice to the Parliament and the Executive through mechanisms established for that purpose by the Parliament. The devil will be in the detail, and we should not underestimate the difficulty of fleshing out the detail, which will come through legislation and ultimately through exercises in cooperative federalism, which are essential for coherent policy delivery. Thank you.
Thank you, Mr. French. Mr. Wyatt.
Thank you. And firstly, can I thank both the former Chief Justice and Sophie for their presentations. What a day to be doing this in light of the Prime Minister's press conference this morning, statement this morning surrounded by the referendum working group, a very emotional press conference for many people, including the Prime Minister. And many of those people, those Aboriginal leaders standing with the Prime Minister, had spent pretty much their entire lives getting to this point. So this is a very important point in time that I guess I'll call the sort of the first part of the final act to an actual referendum, hopefully a decision by Australia around the voice. Sophie's outlined how we kind of got here, and Mr. French has talked about the history of the Constitution, and I will build on that to a certain extent, also build on this topic of cooperative federalism and the role of the states and what potential impact a national voice may have on state policy and state engagement with Aboriginal people. Obviously, the first point being about recognition has been well ventilated by the Prime Minister and others, and certainly in Western Australia, wasn't that long ago. Colin Barnett was Premier, where we passed in the Parliament an amendment to our Constitution. Being a state parliament, a state constitution, we don't have to go through the tiresome process of referendum. It was just debated and passed through the Parliament to recognise the traditional owners of Western Australia, specifically to the Noongar people, but more broadly the traditional owners of Western Australia. That happened without, I think your average Western Australian probably doesn't even know that happened. It was without any contention, and it's existed in the Parliament, in the Constitution of Western Australia now since 2014, from memory, 2013, 2014. So the recognition component has effectively two components, obviously around recognition of our historical legacy of colonialism and the impact that has had, and we really see that on a regular basis through the KPI, if you like, the Closing the Gap initiatives, which tends to cause more, if anything, more frustration and disappointment. But that data set that we see is really, I guess, that KPI, if you like, about success of Aboriginal policies or lack thereof. And the second component, of course, is how do we go about using that recognition to deliver, in this case, a voice to get that better outcome around Aboriginal relationships. And it's important to think about relationships between the voice and the country, state and territory governments. And the reality is, the former Chief Justice, Mr. French, effectively said this, is that the Commonwealth actually has very little direct role in the delivery of programs to Aboriginal people. It's not the role of the Commonwealth government. The Commonwealth is a very large funder of programs that service Aboriginal people, but by and large, it's the state and territory governments that have that direct relationship with Australia's Aboriginal citizens. Which is why, as we sit here tonight, every single state has some form of voice. That's the simple reality. All governments have moved, or state governments have moved to have some form of voice, and certainly for a long period of time, the Commonwealth government has had a range of what we would call a voice, whether it's ATSIC, whether it was the council led by Warren Mundine. There has been a range of different voices, if you like, that have provided advice. And I reflect back on my time as minister and in opposition, and the reason why they have come about is ultimately governments have sought to find an appropriate mechanism to engage Aboriginal people, because actually delivering policy, successful policy, all governments have recognised as not being terribly successful. And it's not just around ministers and taxpayers. Aboriginal people themselves are just as frustrated as everybody else around lack of outcomes in Aboriginal affairs. And this is, I guess, a key point, that if you accept that Aboriginal affairs policy to this point has failed, and I think 90% of Australians will accept that it has failed broadly on those KPIs that I referred to before around closing the gap data set, then you have to accept there has to be a new way of delivering policy, not just delivering policy, but also implementing it and designing it. State governments have had great difficulty in developing and implementing successful policy that seeks to address these large gaps, the closing the gap data set, basically because there has been a long reluctance from governments of all levels to engage expert and experienced Aboriginal perspectives. It just has been very, very difficult for governments to accept sometimes in the bureaucratic apparatus that they aren't the experts on all things Indigenous and do therefore need to engage. But governments have, over a long period of time, including my time in Parliament and in government, struggled to understand the Aboriginal context. Who should government speak to? Who should departments speak to? Who has the authority, the respect to actually provide that advice to government? What has happened in Western Australia is quite striking since 1993, the Mabo decision of the Native Title Act. The state that was perhaps the most opposed to the idea of native title has actually come, in my view, the longest journey in respect of Aboriginal relationships because of what has happened under the native title regime. And I'll come back to that in a minute. But I do want to talk to one thing that I've talked ad nauseum, it feels like, around this issue of a voice. Western Australia has had a voice embedded in legislation since 1972. So the Aboriginal Affairs Planning Authority Act, and I'll read out Section 18, there shall be established a council to be known as the Aboriginal Advisory Council for the purpose of advising the authority, in this case the department, on matters relating to the interests and well-being of persons of Aboriginal descent. And the law went on further to say the council shall consist of persons of Aboriginal descent chosen by and from persons of Aboriginal descent living in Western Australia in accordance with such methods and in such number as the minister may from time to time approve. That has been part of the Western Australian legal landscape since 1972. The clear weakness and the success of the Aboriginal Advisory Council has risen and fallen on the interest of the Minister of the day. It is accountable to the Minister as appointed by the Minister. The numbers on the council depend on the Minister, and over the course of its existence, the Aboriginal Advisory Council has gone from numbers of one, a person being the Aboriginal Advisory Council, through to when I was Minister, I appointed two from each region of Western Australia, a male and female from each region of Western Australia. It's still appointed by me, so it always had ultimately a lack of authority, regardless of how good the people were the Minister of the day appointed. And ultimately, it was always very much isolated to providing advice to the authority, to the department, not so much to the government. And over time, you see each agency, health and others, have developed their own effective, their own forms of engagement with Aboriginal people. The high watermark of the Advisory Council, and this is why there has been such a strong desire for the Aboriginal leadership in Australia to embed a voice in the Constitution, indeed, as now every state government wants, embedded in the Constitution. A good example is because the high watermark of the council occurred just not long after Jeff Gallop became Premier. And the council MOU was signed with ATSIC around effectively creating the state to call on what was the quite credible representative structure of ATSIC, not the kind of program delivery component of it, but the actual representative structure, the regional structure of ATSIC, that actually was probably the strength of ATSIC. And so the Gallop government used the Advisory Council, it effectively became that, and it became the same mechanism advising not just ATSIC in its program delivery, but used by the Gallop government. And that was actually reasonably successful until ATSIC was abolished. Hence, there is that weakness of abolition is why Aboriginal leadership across the nation is very determined to have the voice embedded in the Constitution. And I will make this one point in respect of Section 18 of the Aboriginal Affairs Planning Authority Act that set up the council. At no point, has that become the source of a cause of action in the Supreme Court of Australia. It's simply because I suspect it's clear it's an advisory nature. So it hasn't actually been utilised by any clever lawyer to get an outcome or challenge a particular decision of government. One of the points I also like to make is why, when I speak to people who need to be convinced around the voice, is how a voice will get a better spend of your taxpayers' dollar, because ultimately that's it's often the critique made around the voice and whether it's actually going to have any impact whatsoever. So I use the council quite extensively, not just as Minister for Aboriginal Affairs, but as Treasurer and Minister for Finance. And there are a range of policies that came from that engagement. The Aboriginal Procurement Act, the Aboriginal Procurement Policy in Western Australia is a direct result of the Aboriginal Advisory Council. Various positions on native title. So we shifted as a state government from challenging native title decisions to very much agreement making, which led to, in particular, the Ngangumarta agreement had already been very well advanced, but the Yamatji agreement came about as a result of a strong engagement with the council. And the most obvious example of where you get very successful outcomes when you actually speak to Aboriginal people was that when our response to COVID, you may recall, what was the single biggest movement of Aboriginal people around Western Australia really since we moved Aboriginal people off the pastoral stations, to be honest. But that was done because we took advice from the council, advice from Aboriginal people, whether they be the traditional owner groups under the Native Title Act, under rep bodies or PBCs, and that which is why there was such a successful response by Aboriginal Australia to COVID, in particular in Western Australia. no government could have got away with that without actually having strong partnerships with Aboriginal people. Western Australia, I'll conclude by just making a couple of quick points on native title. Native title now is embedded within the Western Australian landscape, government and the private sector, that you've actually got to speak to Aboriginal people if you're going to do anything really on country. And if there's a prescribed body corporate that holds native title in an area, you can no longer get away with simply ignoring them or not engaging them, or even further getting very much epic around what it is you want to achieve. And Jukan Gorge, I think, for me, cemented that broad view that Aboriginal people hold the agency, they hold agency over their decisions around what is significant, what is not. And it would be stunning that if the country that was so furious about what happened at Jukan then voted against the whole idea of a voice, I'd be completely stunned if that's where we end up as a result. So I think our position internationally would be surprised that a country that reacted with such fury would then not vote to embed a voice. Mr. French has already made comment around the issue of detail. I always see that, to be honest, if I'm still fighting with people over detail, I suspect they're never going to support a voice, because ultimately everyone on this call is a lawyer. They've all got a copy of the Constitution. It is a slim document. It is not the place for detail. I think the design principles that have been outlined today by the Prime Minister and the working group provide a lot more flesh, I think, to that to the constitutional bones about what it might look like. But ultimately, Aboriginal people also don't want too much embedded in the Constitution, because you want the Parliament of the day to be able to react and change and reform over time. You put too much in the Constitution, then you're going to have to go back and forever trying to get referendum to actually make changes that that I think are best made through the parliamentary process. And the final point I'll make is you will see, I think, after a successful referendum and the voice has been established by the Parliament, you will see, I think, a better alignment with the state governments and the voices that they have, and hopefully the fragmentation that exists at a Commonwealth state level around Aboriginal policy and who funds and who delivers will over time become a much more efficient process, and therefore that taxpayer's dollar spent better. So that's why I think the voice, not just in terms of the recognition and resolving our historical legacy with our colonial legacy, but actually why we get a better policy outcome in Aboriginal affairs, it will deliver on both.
Thank you so much. Thank you to all of our speakers today, actually, for that. I engage in this space quite a lot, and I found that I learned quite a few things. So I really appreciate that. Going from the background of where we came from and why we're here, I think is really important, because we hear a lot of concern from the public about the short period of time from the announcement to referendum, and it's not, but a lot of people just aren't aware of that background. The constitutional issues are so important, and although many people on the call are lawyers, hopefully we have some in there that aren't, and I think not everyone is intimately acquainted with the Constitution the way we are after law school. So that's really important. And then to hear about the fact that it is already happening and these things are having positive impact on people, it's really important to share that as well. So I think that's a fantastic way to end up, or end the first part of our session. So the first question, and thank you so much to the members of the audience as well who have submitted questions in advance. First question that I'd like to ask is, as we said, today's a big day in terms of announcements. Do you have any reflections on the updated question today? Mr. French, we might start with you. Does the detail released regarding these representations, particularly in relation to the executive, and you mentioned the Commonwealth, change your view, or do you have any ideas about that?
No, I think the way there's a lot of punching at shadows about things that might possibly happen, but in the end, I think the way in which representations are going to be made and the protocols and stuff will be part of the legislation, and a lot of the apprehended risk, I suspect, will go away. There will be those who say that whatever you put into the laws, there's still some constitutional implication that representations have to be taken into account in connection with the exercise of executive power and condition the exercise of executive power. But my own view is, for the reasons which I already mentioned briefly, that really is a step too far. I think and very unlikely to get up. I think what we really have to hopefully focus on is a workable mechanism for making representations to ensure that they are targeted. You know, you're not just picking off heads around the public service, and that's why I suggested that perhaps one model might be you go through the minister. There might be other places where you might have a statutory authority of some kind, you might have a special status, you can deal with that by regulation. Making them mandatory, relevant considerations would, of course, invite judicial challenge. I suspect that what will, you always have to ask the question, well, by whom and for what purpose? But I suspect the real power of the representations will come from the democratic legitimacy of the voice and how those who are operating it in the early days carry it out in such a way that it looks disciplined, it's targeted, and has credibility. I think the establishment of what I might call democratic credibility is much more important than justiciability.
Yeah, and that'll be where it gets its power, absolutely, in terms of convincing governments to change policy or amend things. The only thing I'll add is I was always curious by the argument that the executive should be excluded. It should just be, and also it can't be proactive. It should be a reactive body to the Parliament of the day, because it also just doesn't have any real understanding how kind of government works. I mean, ultimately, ministers who are going to introduce legislation would never just introduce and wait to hear back. I mean, you're going to engage and try and get a relationship that works. But it's, I think, my view of the question and the proposal now is it actually means it can, and being specific about being proactive, I think it should get a good outcome from a body of hopefully democratically credible people who will then be able to actually influence policy, probably across a fairly broad spectrum, in a way that challenges government, not in terms of legally challenges government, but challenges government to explain why they take positions. I think that's a good thing.
You do have to accept, of course, human nature being what it is and our experience being what it is, that there will be diversity within First Nations people, outside the framework of the voice, or maybe even within the voice, there might be disagreements. And that's something, we all experience in the operation of ordinary democratic process.
That's right.
Yes. Sophie, do you have anything else to add?
Yeah, well, the question is intended to be simple and straightforward and straight to the point of asking whether or not the voter agrees that there should be voice. And I think seeing the final wording today, I think it's very clear and simple. And then the amendment, to me, I thought is legally sound. It respects democracy and parliamentary sovereignty, and it aligns with the Uluru Statement and the principles. So
I think that's a really important point. A lot of people have raised concerns about the lack of detail, but really the question is asking you, do you feel personally that these people, the whole of the Aboriginal people, should be represented in the Constitution? And the answer for me is yes, but that's the question you have to ask yourself. It's a yes or no answer, and you don't need to think too much about the detail to know how you feel about it.
yeah.
So in your shortest and simplest words, what do you think the voice will and won't do?
The voice will give us a say in issues that affect us, because historically decisions are made about us without us, and this will allow us to have a say in those decisions. And now I'm speaking in a lot of words, but it will give that, whereas it will not be a third chamber of parliament, as was mentioned before. It will not have a veto power. It will not control funding and programs. It's really there to serve a role to represent the views and give a voice to our communities in issues that affect us. Thanks.
Ben, do you want to add to that?
Yeah. Won't fetter Parliament, won't fetter the executive. It will result in better delivery of public policy for Aboriginal people.
It's an important one. Given the breadth of the breadth of diversity across the communities, there are approximately 250 nations and languages. Each one has their own desires, and they all face complex issues. How can the voice adequately represent all people, all Aboriginal people in Torres Strait Islander people?
Well, my response to that is it still doesn't replace representative bodies of prescribed body corporates or local Aboriginal communities that are managed under their own structures. But what it does, it's much more higher level than that, of course, focusing on Commonwealth policy and Commonwealth laws. Its own legitimacy is going to be how it also forms partnerships across the nation with different Aboriginal groups. But I don't see it as speaking before, whether a road goes through a particular area in a part of Western Australia. That's not its responsibility. There'll be local Aboriginal people, local traditional owners, so that's their role. It's more high level than that.
I think from the way that you described it before, Mr. French, when you were talking about the proposals that had been put together, it sounded, and this is my personal view, not the view of Piddington Society, but it sounded a lot more diverse than the current Parliament. So I think it's actually, provided that the thought goes into it, there's a role for sort of everyone.
I think one of the important things for representatives who sit on that body that we call the voice is their recognition, which will come from their own lived experience and their constituencies, of the diversity of First Nations people and of their problems. And one of the implications of that might be to closely scrutinise one-size-fits-all policies. A policy which might work in a near-urban or near-regional town situation, for example, may not work in a remote regional area. And for example, you might talk about social services provisions that create particular problems for communication, say, providers in remote areas which don't exist to the same extent in major regional centres or urban areas.
Sophie, did you have anything to add there?
Just that the ALP has committed to a process of consultation on how that the voice will actually be composed. So they will undertake rigorous process, and all of that detail will include how many representatives, how they will be elected by their communities, and this will all be done with the working group as well, and who they represent. And that will all be designed according to the design principles, and they're available on the Uluru Statement website if anyone wants to look at them. Those principles will be included going forward, and that's, for example, Principle B is that the representatives will be chosen by Aboriginal and Torres Strait Islander people based on the wishes of local communities. So I think that's really important to acknowledge that will be consistent throughout.
All those principles would seem to be consistent with the, so far as I recollect, with the Lincoln and Karma model, the co-design model. Albeit they might differ in detail, but that's, the regional elections and also people from particular votes. So it's not just a proportionate vote according to the population. You have to recognise the special groups.
Yeah, that's it. And I think it's important as well to know that the government aren't choosing people, they're being chosen by their communities. So it's much more self-determined.
It helps to reflect that context of people that you were talking about before, who to speak to, because they're being chosen by their own community.
Absolutely. And it's also, again, I'll come back to that point I made before, this is all detail you want the Parliament to deal with. You don't want this stuck in a constitution, never to be changed again, right? I think I suspect that parliamentary legislation will be quite significant in its scale. So you want it, and as a result, over time, will be amended reasonably regularly as the voice evolves and learns how it operates itself. It will be new, so you do want the Parliament to be able to react to that.
Yeah, I think that's a really important point, because there have been a lot of voices perhaps not the right choice of word there. A number of people have raised concerns that there is not enough detail yet. I don't think that's true, to be honest. I think there's a lot of information and they haven't been provided or they haven't known where to look. But I think that the fact that if you put too much in the Constitution and you have to have a majority of people in a majority of states to change that later, it's just going to be too hard if it's not working the way it needs to.
And every additional word is an argument waiting to happen. So.
Yeah,
exactly.
Including, yes. Sophie, you talked before about the specific choice of the order of voice treaty truth. There have been concerns raised that the voice may be an attempt to delay substantive improvements in the lives of First Nations people, which will come by way of a treaty. How do you respond to that?
It's the necessary step towards treaty, and you have to have that substantial political power and platform of the right representatives to then move into treaty. So creating treaties, agreement making won't work without having a voice.
Yeah.
Somebody's got to be at the table.
Exactly. Yeah.
That's exactly right. Who do you speak to?
Yeah,
this is the point.
And it just feeds into internal community politics if you don't have a proper process and representatives.
Thank you. And the final question I'd like to ask today, there seem to be in the media and social media two, I guess, macro criticisms of the voice. On the one hand, the voice might be tokenistic and disregarded. On the other hand, it might be meddling or stifle the operation of government. I think we've touched on issues related to this throughout the session today, but are either of these realistic?
Well, I think it won't be tokenistic. Whether its authority will really derive the initial impetus from the democratic legitimacy of a referendum, which says we want a voice. To continue that impetus, you'll need effective operation, and that will mean a lot of work and responsibility for the people on the voice. If it becomes too intrusive into granular detail, then there might be a parliamentary reaction to that, and in any event, it might lose authority because stories would be ventilated about, bureaucratic difficulties and so forth. So I think a lot turns not on the legalities, but on the performance of the people who make it up.
Yeah, and look, that's the perpetual argument you have. People say, "Oh, you don't want to bind the parliament." Okay, let's not bind the parliament. Well, what's the point of advisory body? So you find yourself, well, what is it? What is it that people will accept? I mean, this is, as Sophie went through this earlier on. This went through a long process within the Aboriginal community about Wyatt and constitutionally entrenched voice. We're broadly accepted. It's not there to fetter Parliament, but it's there to be required to be listened to. Is something that Aboriginal Australia sees as important. I've tried to give examples. I always try to give examples of where you just get better policy outcomes when you actually engage and consult and listen and react. And you do get better policy outcomes. So I don't see it as either symbolic, not having a practical outcome, nor do I see it as the only solution that we're going to have to have. But certainly, in terms of how government goes about its own policy design and delivery, the voice will have, in my view, a dramatic impact over time.
I think it's not tokenistic, and it won't be tokenistic because it's substantial and structural reform. And the fact that it has to go through a referendum process means that if it's successful, Australians have spoken and regard it as a legitimate institutional body. And it also can have an accountability mechanism, which feeds into it being substantial and structural and not tokenistic, whereby there can be political consequences if the government doesn't take advice of the voice. For example, they will likely have to provide reasons why they're not taking the advice of the voice on a given matter and make that available to the voice, to Parliament and to the Australian public. And that creates real change and real accountability, which there hasn't been before, especially when you think about decisions in native title and land use, things like that. And then as to the second part about whether it would meddle and stifle the operations of government, it will improve democratic and decision-making processes because better decisions will be made with that input.
Yeah, that critique assumes that government has been operating really well in the space for a long period of time. And that I think everyone can agree is not the case. Yes.
Thank you all so much again. That brings us to the end of today's seminar on the Aboriginal and Torres Strait Islander Voice to Parliament and the upcoming referendum. Thank you to everyone online as well for your time and engagement today. We hope firstly that you leave the session with a little more knowledge than you had when we commenced. And secondly, that you share that knowledge with your families, your colleagues and your communities in the lead up to the referendum. Thank you once again to our panel for sharing their insights on this big issue that is only going to come more into focus the closer we get to the referendum. For those of you requiring those last prized CPD points before the end of the CPD year, we will issue certificates and uploads to the Legal Practice Board before the end of the month. Until next time, stay safe and stay informed. Thank you.